We will send you an email or text when the Dallas Lockbox facility accepts your Form I-129F. If you clip a completed Form G-1145, notification of acceptance of application petition, to the front of your petition. Okay, let's do that. Let's look at this form here. This is a very simple form to complete. So here we are, notification of application petition acceptance, and here it is. That's all it is. It's let me move it up here. Yeah. The only thing you got to really fill in this thing is the very bottom. And for some reason, I'm not getting sized right, so let me just start over. Here we go. It is. Of course you can read that. What's the problem? No. So complete this form and clip it on top of the first page of your immigration form. Okay, great. You got your full name, full last name. There it is. Full first name for the applicant, the petitioner, applicant petition full middle name, email address, mobile telephone number, right? So you complete this form and clip it on the top of your first page for immigration forms. That's why they know it's all clipped together and it's easy for them to figure out. So there's that one, and we've got one here that we're going to be doing. Okay. So let's bring this thing back up again, and let's resize it to where we can actually look at what's going on. Okay, filing fee, $340. There's no fee for petition K3. Okay, great. Now the filing fee, you'll see in there when we get the instructions how to make out the check and how to make that payment. Special instructions. Citizens petitioning for K3, not doing. Marriage certificate, not dealing with. Additional information about K1 and K3 visas available at these links. Department of State link. Non-immigrant visa for Fiancée K1. We've been here before. We love this link. This is travel.state.gov. You probably recognize this. And this is the powerhouse of information for all things Fiancée visa. I mean, this really does have amazing information on it. And it's going to give you, and we've been through this line by line, note by note, but there's a link to it here. So again, you when you're going through this, you know, your questions can get answered in a good way through that. So let's go back then and let's look at these instructions. There's that G1145. We've done that. So let's look at the instructions now. Instructions to the form. Probably need to do a little resizing on this. Let's see here. Okay. Instructions for Form I-129F, petition for alien fiancé. Please read these instructions carefully to properly complete this form. If you need more space, complete an answer, use a separate sheet of paper. That's right. You write your name and alien number, if any, at the top of each sheet of paper, and indicate the part and number of the item to which the answer refers. So what they're talking about then is if you have attachments to this actual form, if they ask a question and you need more room to actually put it in, even if the name of the city is really, really long, doesn't fit in a box, you can attach a piece of paper to it, but you want to write your name, you want to say this is an attachment to Form I-129F, and you want to put the question number in there so that they can actually consider that information along with the petition. All the other evidence, the phone bills, the photos, you know, all this stuff, letters from friends and family, you don't need to do that. That stuff is not going to be actual extensions of the form, right? Those are documents in support of the form. You don't need to actually write that stuff on that. What is the purpose of this form? This form is used to bring to the United States your fiancé for marriage to you and his or her children. Great. Your spouse and his children is non-immigrants under the Life Act. Okay, we're not doing that. General instructions. Fill out the form I-129F. Type or print legibly in black ink. Check. Extra space is needed. Attach a continuation sheet. Check. Answer all questions fully and accurate. State that an item is not applicable with, quote, NA. If the answer is none, write none. Okay. Little distinction there, right? So General requirements. Compliance with the International Marriage Broker Regulation Act. Okay. If you met your fiancé or spouse through the services of an international marriage broker, you must notify USCIS of that fact by answering question 19 on this form. The term international marriage broker means a corporation, partnership, business, individual, or other legal entity, whether or not organized under any law of the United States, that charges fees for providing dating, matrimonial, matchmaking services, or social referrals between United States citizens or nationals of aliens lawfully admitted to the United States, right, as lawful permanent residents, and foreign national clients by providing personal contact information or otherwise facilitating communications between individuals. Some of these organizations are human trafficking organizations. So if you are working with a marriage broker organization, they want to know because they're going to go check them out. The term international marriage broker does not include traditional matchmaking organizations of a cultural or religious nature that operate on a non-profit basis and in compliance with the laws of the countries in which it operates, including the laws of the United States. So they were talking about church groups and that kind of stuff. Entities that provide dating services, if their principal business is not to provide international dating services between the United States citizens or United States residents and foreign nationals, and charge comparable rates and offers comparable services to all individuals it serves, regardless of the individual's gender or country of citizenship. So like a Match.com or something like that as a dating, but it's not principally for funneling foreigners into the U.S. to satisfy the U.S. market. For additional IMBRA requirements, see items 7 and 9 of these instructions. Okay, so that's pretty clear. Filing limitations on K-1 immigrant petitioners. Oh, this is an interesting one too. Let's put this up a little bit. There we go. If you have filed 2 or more K-1 visa petitions at any time in the past or previously had a K-1 visa petition approved within 2 years prior to the filing of this petition, you must apply for a waiver. To request a waiver, you must submit a written request with this petition accompanied by documentation of your claim to the waiver. If you have committed a violent offense against a person or persons, USCIS may not grant such a waiver unless you can demonstrate that extraordinary circumstances exist. For details regarding those circumstances, see item 7B of these instructions. So the waivers are a huge deal. All right, they're way beyond the scope of this video. We are not going to go into a scenario where a waiver is required. If you feel like you need a waiver, do call an attorney. Check in with an attorney who can help you draft a waiver. I have drafted waivers. They are doable. They're complex, and you're not going to get it unless you get one. So if that's the situation, you got to kick it in and do this. What documents do you need to show that you are a U.S. citizen? Okay, we know that. Born in the United States. We covered all that stuff. What if a document's not available stuff? We've been through that. Let's switch over here. The baptismal certificate, census, affidavits. We know this. What documents do you need to prove that you can legally marry? Okay. Provide copies of evidence that you and your fiancé have personally met within the last 2 years, or if you've never met within the last 2 years, provide a detailed explanation and evidence of the extreme hardship or customary, cultural, or social practices that prohibited your meeting. We've gone through this. We talked about that case, and so we know about all that stuff. Provide original statements from you and your fiancé whom you plan to marry within 90 days of his or her admission and copies of any evidence you wish to submit to establish your mutual interest. We showed you how to do that. There's sample letters in this packet, so we can definitely take care of that. Check. If either age requires special consent or permission to marry, where jurisdiction marriage will occur, give proof that that consent or permission, and if either of you or your fiancé were married before, give copies of documents showing that each prior marriage was legally terminated. All right, so like in Tennessee, some states in the United States, when you go to get married, and if the person is 16 years of age, you can get married, but you need consent from the parents. That type of stuff. So make sure that consent is actually in there. What other documents do you need? Submit a completed and signed Form G325A for you and a completed and signed Form G325A for your fiancé. Great. check. We're going to be covering those right after the I-129F here. Except for name and signature, you do not have to repeat on the biographic information form the information given on your form on I-129F. Well, that's great, but we're going to provide a complete G325A, even though we repeat the information, because we like to give a form that is fully filled in and executed, signed. And we're not going to ride on the time saving of a couple minutes just to avoid having to put in your address twice. Put your address in twice, people. Give USCIS a passport-style color photograph of yourself and a passport-style color photograph of your fiancé, with both taken within 30 days of the date of filing this petition. And so we have, we've gone through the photo sheet and the photo requirement, of course. Either you or your person who are filing for is using a name other than that shown in the relevant documents. You must give USCIS copies of the legal documents that made the change, such as a marriage certificate, adoption decree, or court order. So if you are using a name from a previous marriage, then you need the marriage certificate, actually. Even though it says right here, in a fiancé visa situation, you're obviously going to be divorced, right? We've gone through the divorce stuff. A marriage certificate is going to be required to show where the source of that name actually came from. So for that reason, you may not want to use, if you can't have that marriage certificate, you may not want to use that name on the application as the name they're going to be filing under. Just put it as a other name used. What documents do you need to comply with the International Marriage Broker Regulation Act? Here we go. This is number 7. So, if you've ever been convicted of any of the following crimes, submit certified copies of all court and police records showing the charges and dispositions for every such conviction. This is required even if your records were sealed or otherwise cleared, or if anyone, including a judge, law enforcement officer, or attorney, told you that you no longer have a record. Very important, because the federal laws supersede and control state laws, local laws about what is a crime and what's not a crime for immigration purposes. So it's true, an attorney might say, we got that expunged. You don't need to put it on a job application. You don't even need to say anyone that you're convicted, it's as if you've never been convicted of that crime. Wrong for immigration purposes. Wrong, wrong, wrong. And so we definitely want to go back and look at the criminal thing where we showed you, remember we showed you FBI fingerprint check, doing all that stuff. This is where it comes up, because it's really important that you have that available. So, domestic violence, sexual assault, child abuse and neglect, dating violence, elder abuse, and stalking. The term domestic violence includes felony or misdemeanor crimes of violence committed by a current or former spouse of the victim, by a person with whom the victim shares a child in common, by a person who is cohabitating with or has cohabitated with the victim as a spouse, by a person similarly situated to a spouse of the victim under the domestic or family violence laws of the jurisdiction receiving grant monies, or by any other person against an adult or youth victim who is protected from that person's acts under the domestic or family violence laws of the jurisdiction. So we're given a description of what is a domestic violence based on a relationship, right? So a person with whom the victim shares a child in common, cohabitating with or has cohabitated with the victim as a spouse by a person similarly situated to a spouse of the victim under the victim. So they're saying common law marriage, obviously you're not a spouse, but similarly situated, right? Or any other person against an adult or youth victim is protected from that person's acts under the domestic or family violence laws of the jurisdiction. So even if you guys were roommates, if they considered that in the local laws to be a crime of domestic violence, for federal, it is as well. So it's going to flow up, all right, even though it's not, under this definition, you don't have any kind of marital relationship, family relationship, it's still under the local laws say that it is, then it is, right? So this is what's so confusing about criminal law and immigration, right? So if you're going to say, it was expunged, it's not a conviction. Federal law, so we're not going to pay attention to you, state, right? If the local law says, even though you're just cohabitating, we do consider that to be domestic violence, even though you have no relationship, then the federal law is going to go, oh yeah, that's true. We're going to agree with that. So they use it as a need to put forward the goals that they have to keep people safe when they come into the United States. There's the next list here. Homicide, murder, manslaughter, rape, abusive sexual contact, sexual exploitation, incest, torture, trafficking, peonage, holding hostage, involuntary servitude, slave trade, kidnapping, abduction, unlawful criminal restraint, false imprisonment, or an attempt to commit any of these crimes. Okay, so we don't care if they're domestic or not. You do one of those things against anybody, obviously, you're going to need a waiver, big time. All right. Now, one of the things around this is that I get a lot of calls about how I got a restraining order put on me. Well, a restraining order is not necessarily, right, in this list. So, but if you have a restraining order and you have questions around it, you're going to want to talk to an attorney to do the research. All right. Because a lot of times restraining orders are civil law, they're not criminal law, right? But what if the restraining order says something like, there was an offensive touching between the husband and wife, that might consider to be a conviction, even though it's civil. So this is where immigration law gets really crazy, and why you need to have an attorney actually sit down, read what the document is, go to the books. We have books like Kurzban, and having your attorney dive in and do that research for you. And then you can make an assertion that, no, it was not a crime of domestic violence. It was a restraining order, and there was no mention of any kind of violence or any kind of, activity between husband and wife. It was a civil matter. We're not going to even include it in here, right? So, but you're going to definitely want to have an attorney guide you if you're not going to reveal that there was a restraining order. Crimes relating to a controlled substance or alcohol on 3 or more occasions, and such crimes did not arise from a single act. So, habitual drunkard, DUIs, small marijuana, infractions or whatever, if it relates to a controlled substance or alcohol, you're going to have to get a waiver for that. Note, if your petition is approved, a copy of your petition, including the information you submit regarding your criminal convictions, will be provided to the Department of State for dissemination to the beneficiary of your petition pursuant to Section 833A 5A of IMBRA. In addition, so they're going to tell your fiancé everything about you that falls into these categories. In addition, pursuant to Section 833A 5A of IMBRA, any criminal background information pertaining to you that USCIS may discover independently in adjudicating this petition will also be provided to the Department of State for disclosure to the beneficiary of your petition. You should also note that theft, shoplifting, they might, those are moral character issues. They might, even though they're not domestic violence or something, they might go ahead and disclose those as well. You should also note that under Section 833C of IMBRA, the name and contact information of any person who is granted a protection or restraining order against you, or of any victim of a crime of violence perpetuated by the petitioner, will remain confidential, but that the relationship of the petitioner of such a person or victim, spouse, child, etc., will be disclosed. All right. It was granted a protection or restraining order against you. So there we go. I mean, so the name and contact information, protection, restraining order, they're going to divulge it, but you may not need a waiver for it. So this is why, again, you need to talk to an attorney, and the bottom line is you really need to come clean with all the criminal stuff that's happened, and restraining order stuff is a good thing to also disclose if that happened in the course of a divorce or something like that. If you are seeking a waiver of the filing limitations imposed by IMBRA, you must attach a signed and dated request for the waiver explaining why a waiver would be appropriate in your case, together with any evidence in support of your request. Examples of such evidence include, but are not limited to, a death certificate, police reports, news articles, or medical reports from a licensed medical professional regarding the death of an alien approved for a prior K visa. Wow. If you have committed a violent offense and seek a waiver, you must attach a signed and dated request for the waiver, together with evidence that extraordinary circumstances exist in your case, i.e., that you are being battered or subjected to extreme cruelty by your spouse, parent, or adult child at the time you committed your violent offense. So basically, it was self-defense. You were not the primary perpetrator of the violence in the relationship, and you were acting in self-defense. You violated a protection order intended for your protection, or you committed, were arrested for, were convicted of, or pled guilty to committing a crime that did not result in serious bodily injury, and where there was a connection between the crime committed and your having been battered or subjected to extreme cruelty. Examples of such evidence include, but are not limited to, police reports, court records, news articles, trial transcripts, and any credible evidence that is relevant to the request for such a waiver. So again, I'm not going to go deep into this. It's important for me right now, because I can't give you legal advice, to lay the stuff out in a way that's clean and not giving too much of my interpretation, because a lot of this stuff we can actually fight, we can argue as lawyers. There's nuances in the law that they're not putting in these instructions that would really benefit you if you have a situation. So again, call a lawyer if you feel like any of these issues in the waiver or IMBRA affect you in your case. How do you use this form for your spouse seeking entry with a K3 visa? Don't need to know about K3 visa, so let's just go all the way through. Mandatory tracking of multiple petitions and dissemination of information. Pamphlet, okay, it's just saying that the International Marriage Broker Regulation Act requires USCIS to maintain a database to track repeated petitions for K visas. Upon approval of a second petition for a K-1 or K-3 visa filed by the same U.S. citizen petitioner, USCIS will notify the petitioner that information concerning the petition has been entered into a multiple visa petition tracking database. USCIS will enter all subsequent K-1 or K-3 petitions filed by that petitioner into the database. When a subsequent petition for K-1 or K-3 visa petition has been filed less than 10 years after the date the first petition was filed, USCIS will notify both the petitioner and the beneficiary of the number of previously approved petitions listed in the database. USCIS will also send the beneficiary a pamphlet containing information on legal rights and resources for immigrant victims of domestic violence. So there's a presumption then that we've got some trafficking going on in this type of situation. So they're keeping records, and this is a huge commitment by the government to prevent the trafficking of women under fiancé visas. Translation. Any document containing foreign language submitted to the service should be accompanied by full English translation. Got it. Copies, unless specifically required, an original document be filed with an application. Ordinary legible photocopy may be submitted. Perfect. Who may file the Form I-129F? You are a U.S. citizen, fiancé, intending to marry within 90 days, entering the United States, and are both free to marry and have met in person within 2 years before you're filing a petition, unless, okay, we're going through this again. We know all this stuff. Unmarried children. What's the filing fee? Filing fee for I-129F is $340. There's no fee for I-129F petitions for K-3, non-immigrant status. Use the following guidelines when you prepare your check or money order. Okay, here we go. The check or money order must be drawn on a bank or other financial institution located in the United States and must be payable in U.S. currency, and make the check or money order payable to U.S. Department of Homeland Security. Hey, listen to this. Please do not spell out U.S. Department of Homeland Security. Do not use cancel. Please spell out U.S. Department of Homeland Security. Do not use the initials USDHS or DHS, right? Why? Because people with the USCIS will make up names, and my name is David Howard Smith. Oh, they just wrote it to my initials, DHS. They'll steal those checks, man. USCIS has busted their contractors doing that. So let's all thwart the bad guys and don't put in DHS. Thank you. Spell it out, people. Okay. If you live outside the United States in Guam, U.S. Virgin Islands, contact U.S. and U.S. Embassy or consular instructions on the method of payment. Well, yeah. On the method of payment, that's right. Notice of those making payment by check. If you send us a check, it will be converted into electronic funds transfer, EFT. This means we'll copy your check and use the account information on it to electronically debit your account for the amount of the check. The debit from your account will usually take 24 hours and will be shown on your regular account statement. Right. So don't be floating checks around because they cash them quickly. Okay. If you wait until you have the money in your account, I like to use U.S. postal orders, money orders, because they're traceable. You can get them back, and you pay the money out, and the money's gone. So we take money from our trust account, and we're going to purchase a U.S. Postal Service money order and then send it in. Or sometimes we'll write a trust account check. But once it's accepted for filing, we get the e-notification. Boom, that money goes quickly. You will not receive your original check back. We will destroy your original check, but we'll keep a copy of it. If the EFT cannot be processed for technical reasons, you authorize us to process the copy in place of your original check. If the EFT cannot be completed because of insufficient funds, we may try to make the transfer up to 2 times. So they're going to keep it going, give you some chance to get that money in that account. How to check if the fees are correct. Okay, we know how to do that. Where to file. Okay, we've already looked at that. We know this address for this address for express mail. Okay, that's good. Form I-129F petitions cannot be adjudicated at a USCIS office abroad. They used to be able to, but they don't anymore. U.S. citizens petition for K-3 visas for their alien spouses must include a copy of the Form I-797C showing that they're filed. Why am I reading that? Because we're not doing that. E-notification. Okay, we know about e-notification. Questions regarding Form I-129F for additional information about it. You can call the customer service and they will give you some information on it too. Address providing where to file section of the instruction reflect the most current information as of the date the form was last revised. If you're filing I-129F more than 30 days after the last edition shown in the lower right corner, please visit our website online and go to forms. So remember where the hyperlinks were, where we go to the instruction and we go to the form. Okay, excuse me. That is the place where they have the most current address for filing, not on this form. So they do have the address here, but we always check the other address in the other side part of the website to get the most current one. Processing information. How does your alien fiancé obtain permanent resident status? Your alien fiancé may apply for conditional permanent resident status after you've entered into a valid marriage to each other within 90 days of your fiancé entry into the United States. Your alien spouse should then apply promptly to USCIS for adjustment of status to conditional permanent resident using Form I-485 application to register or adjust status. So we have another set of videos on doing the adjustment of status form, because it's true. You come in on a fiancé visa, you get married, you've satisfied the condition of that visa. Yay, you've done it within 90 days. Yay. Now you're ready to go forward and file for the green card. She's not a permanent resident yet. She is a properly admitted fiancé who has fulfilled the requirements from getting married. That's great, but that's not all you got, right? You got to get the green card, because even though she's fulfilled that requirement, if the visa in her passport is expired, she's out of status. And so she is deportable at that point. So she has got to get that green card application, the adjustment of status application, going right after the marriage. And let's see here. How does your spouse become a permanent resident without conditions? Both you and your conditional permanent resident spouse are required to file a petition 751, petition to remove the conditions on residence during the 90-day period immediately before the second anniversary of the date of your alien spouse is granted conditional permanent resident. Right, so the Marriage Fraud Act, they want you guys to get married and stay married for at least 2 years so that they know it's a real marriage. And once 2 years have passed, you have to file a new form, and that brings the case before the USCIS, and they will look at your case again down the road to see if you guys are still married, if it's a good faith marriage. If you jump over that hurdle, and if you get that form approved, and that form is the I-751, then they will give you a 10-year green card, and you're going to be a permanent resident instead of a conditional resident. This is an interesting thing. Children who are admitted as conditional permanent residents with your spouse may be included in the joint petition to remove the conditions. The rights, privileges, responsibilities, and duties that apply to all other permanent residents apply equally to a conditional permanent resident to file petitions on behalf of qualifying relatives or to reside permanently in the United States as an immigrant in accordance with immigration law. So there's really no difference between a permanent resident and a conditional resident, except for the fact that a conditional resident card has an expiration date on it that's only 2 years. And so when the card expires, you have a problem. So get in there and do the I-751 petition to remove the conditions on residents. We actually have another set of videos on that as well. Notice, failure to file Form I-751 petition to remove the conditions of residence will result in termination of permanent resident status and initiation of removal proceedings. And that's really true, and they're not playing around. That deadline is a very serious deadline in immigration law. The deadline for filing an I-751, the 2-year. So, I mean, obviously there's a fiancé visa video, but we're going down the road here because this is so important. I want to make sure that we start getting you acquainted with what's coming up down the road anyway. What are the penalties for marriage fraud or giving false information? Well, let's look at this. Title 18, U.S. Code, Section 100 states that whoever willingly and knowingly falsifies a material fact, makes a false statement, or makes use of a false document will be fined up to $10,000 or imprisoned for up to 5 years or both. I have clients ask me to send in false documents. Can you believe that? And I fire them immediately. You know, it's because government does not play, and my reputation, I do not want my reputation to be hurt like this, because look, all the immigrants that I'm going to help down the road, the Immigration Service remembers lawyers who send in false documents or whose clients are busted for document fraud, and that looks bad on me. So I, vet my clients and figure out, who I want to work with, who I don't want to work with. But the problem is that these fines go to the attorney as well. I guess it's really not a problem. It's not a problem. I mean, some of the documents look so real. There'd be no way that I would ever know if someone passed them to me and I passed them on. But certainly I'm going to get really, really pissed. Title 8, United States Code, Section 1325 states that any person who knowingly enters into a marriage contract for the purpose of evading any provision of the immigration law shall be imprisoned for not more than 5 years or fined not more than $250,000 or both. And the interesting thing about this is that, immigration can be one of the considerations that you have in marrying someone. Okay, you look at the whole pie. You've got, physical attraction, you've got spiritual connection, you've got wanting to have kids, those are the big things, and how compatible we are. And you know what? His visa's expiring in a month, and we got to get married now. We got to get this thing filed now because we don't want him to fall out of status. That's okay. So as part of the whole picture, having an immigration concern, wanting to file things now because of immigration is totally okay. But when the whole thing is, I'm paying you $10,000 so you'll file this application with me, right? That's an immigration-driven application that has very little to do with, I like him, okay. That's the $250,000 problem that you're going to be having if you go down that road. Really, my emphatic request is to don't go there. Do not go there. Any form I-129F that is not signed or accompanied by the correct fee will be rejected. We know that. Initial processing, okay. There's a little bit about once an I-129F has been accepted, it will be checked for completeness, including submission of required initial evidence. If you not completely fill out the form or file it without required initial evidence, you will not establish a basis for eligibility, and we may deny your form I-129F. That's right. So, that's the thing about like sending in a supplemental thing. If you don't send in enough, you can get it denied. So if you're going to send supplemental stuff, you need to do it quickly because before the initial processing is done. Request for more information, we kind of went through that. That if you don't give enough, they're going to do that. And then decision. Of course, again, decision on a 49 I-129F involves a determination of whether you have established eligibility for the required benefit. You'll be notified of the decision in writing, right? And here's the thing about the decision, and that is that the legal standard is the preponderance of the evidence. So the preponderance of an evidence, if you look at the scales of justice, it's 51%, right? It's just tipping it over. You've got a preponderance of the evidence. It's not like clear and convincing evidence where you have to like 85, 90%, right? And a lot of immigration people don't remember that. They feel like you've got to prove 100%, and it's not. You do not need to prove. It's a preponderance of the evidence. But we like to go for the clear and convincing evidence. We like to make our applications this kind of an application rather than just squeaking by, right? We want to make sure that we've got a lot of evidence to prove it. Here's the address change. Uscis forms and information. An alternative to waiting in line for assistance at your local USCIS office. You can schedule an appointment through the USCIS internet-based system InfoPass. To access the system, visit the USCIS website, use the InfoPass appointment scheduler, and follow the screen prompts to set up your appointment. InfoPass generates an electronic appointment notice that appears on the screen. InfoPass is great. If you're waiting for your I-129F and it's way beyond the processing time, you can go take an InfoPass appointment and go to your local office and ask what's going on with the service center, and they can put through a request for you. You can do it on the phone as well, but it's also really powerful to go do an InfoPass appointment, because I've seen the people at the office when I do an InfoPass appointment. They'll get on the phone and they'll call the actual service center sometimes, and they'll have a conversation. And they'll tell you the file is lost, or the file went to archive, or you got denied, I guess you never got the notice, or whatever, whatever weird thing has happened. So, or you're going to be having an interview. We're scheduling an interview for you because we don't believe what's going on in your petition. So InfoPass is a good procedural thing to keep in your mind if you really need that. Okay, there's the penalties, the Privacy Act stuff. And let's see what else we've got here. This is kind of the boilerplate stuff. Routine uses, USCIS compliance review and monitoring. And I think that's about it with the instructions. Last page. Yeah, this is all the government stuff, talking about the form, how long it takes and everything. Great. Okay, there's your instructions. There's your I-129F instructions. And, there's a lot of information there. It's good stuff. Now we're going to go into the form. All right, so you're going to click on the download the form I-129F. Okay, so we've gone through the instructions to the form. Here is the form. It's the I-129F. Now, this is a completed form, and I've done it this way because, we've gone through now all the documents relating to the intake sheets. We have all of the questionnaires. We have the documents with the letters from friends and family, from each other. Everything we need: birth certificates, divorce decrees, all that stuff. Tax returns. So all of those documents then have names on them and information, and we've taken the information and put them into the form in this way, so that if you need a tutorial again on it, you can see how we pulled the document name from a birth certificate and put it into this form. And so you'll do that obviously on your own documents, but this is modeling for you how to assemble this information given the basic documents that you have provided and that you've assembled. So we start with this 2-column I-129F. So we have here, start here, information about you, and then information about alien fiancé. Great. So I'm going to expand this a little bit like this, and I'm going to bring this over so we have a nice shot at this. So family name in caps. I like to put everything in caps. Now, you can bring them in lowercase if it's not enough room. Lowercase, you can get more lowercase characters into a field than a caps, but for copying and faxing and transmitting these forms, I like to put everything in caps. So Parker Timothy Randall, right off his birth certificate. Address, there it is. He doesn't have an apartment number. It's Nashville, Tennessee 37210. That's obvious. Place of birth, okay, off of his birth certificate, Flint, Michigan. Date of birth, 4/28/1981. Let me back up a second. There are issues around address. Like, obviously the name is off of the birth certificate, but address. How about if we're moving in between two places? Well, you know, we want to be as accurate as possible with these forms. So if you are living in 824 Nelson Drive and next week you're going to be moving, what I would suggest you do is put 824 Nelson Drive on these forms because that's where you're actually living today, right? Now, that having been said, you know, once you file it, you'll get the receipt notice back, and then if you'll have a tracking number on all of your information, you're going to be able to fill out a change of address at that point. But the question becomes, well, what about the receipt that I get back? If I'm moving in a week and it takes 2 weeks to get the receipt, that means the receipt's going to my old address, all right? So that could actually be a problem. So if you absolutely know that you are going to be in a place in a week, then I would say put the new address in there. Put the new address in there, and that's going to be that will not be a misrepresentation because, you know, your residence is where you intend to permanently reside. Now, on your information about where you've lived for the last 5 years, of course, you'll put both of those addresses, the one you're living in now, the one you're going to be living in. But only if you really know that you're going to be moving into a new place within the next 2 weeks would I say it'd be okay to put the address for a future residence into this box. Otherwise, you're going to want to put the address where you're living. If you know you're moving in a month, put the address where you're living now. And when you get the receipt notices back, put in a change of address after you've actually moved. That's the proper way to do it. Place of birth, as indicated on the birth certificate. Date of birth, male. Marriage status, single. Okay, other names used. There's none. Now here's the including the maiden name. So for women, then again, that's where we're going to put the maiden name. If men have used other last names, hyphenated names, or they want to do a hyphenated name now, they put their single name here, that's fine. U.S. Social Security number, a number, if any. Okay, so here's a situation then where it says, if any. So here is where we would put none, because there's no a number for this guy, right? Or we could put in a, because he's a U.S. citizen, right? But I think more applicable is none on there. And again, I like to use all caps, none. Names of prior spouses, Sarah Shipman, all right. Date marriage ended, 4/25/2011. This is off of the divorce decree. And let's see, my citizenship was acquired through birth in the U.S. If it was naturalization, then of course we put the number of the naturalization certificate, date and place it was issued. All that information is actually found on the naturalization certificate. Parents, have you obtained a certificate of citizenship in your name? So if I've got my citizenship through my parents and I don't have a certificate of citizenship in my name, that could be a real problem. You know, I might have a passport, but you know, if you if it's no, then you can put passport. If it's yes, of course, give the certificate number, date, and place it was issued. Have you ever filed for this or any other alien fiance or husband before? No. If yes, give all the aliens place and date of filing, a numbers and result. Attach additional sheets as necessary. So I think we probably want to attach additional sheet. And remember that question is being asked because more than 3 petitions and you need a waiver. So that's a very important question. So we put no on there and we're all good. Now let's go to this next column about the information about the fiancé. Move this over a little bit. So her name, King Anne Elizabeth. Address, this is her Toronto address. And place of birth is Toronto off her birth certificate. Country of citizenship, it's on her passport. She has a Canadian passport. Date of birth, female, single. Other names used, none. She's using her maiden name right here. We're not married yet, so that's fine. Social Security number, she has none. A number, none. Date of prior, names of prior spouses, none. Date marriage, and just, I mean, you could put in A here if you wanted to, because that would not be applicable. And I will get a cap. Here we go. In A. So that's a good one there. Has your fiance ever been in the U.S.? Yes, she has. If your fiance is currently in the U.S., complete the following. Okay, not applicable because she's not in the U.S. right now. Arrival departure record number, that's not applicable either. But see, they won't let us put in here, will they? In, like I said, well, /A. Look at that, yeah. Date of arrival. Let's put an in A on this as well. Date expire and A. There we go. Look, page 1 done. Page 2. Part B. Children of all your alien fiancé, none. Okay. Address in the United States where fiancé intends to live. Well, this is his address, so the petitioner's address is there in Nashville, Tennessee. That is great. And fiancé address abroad is all of her address back home. Phone number. If your fiancé's native alphabet uses other than Roman letters, write his or her name and address abroad in the native alphabet. Not applicable. But this is an interesting one because look, if you if the alphabet uses other than Roman letters, you're going to need to write this. So if it is in, Hindi or Gujarati, then you're going to need to write it in Gujarati. She doesn't actually have to write it. Someone does, though. Is your fiance related to you? No. Okay, so if you have a third cousin, maternal uncle, those relationships are okay, but of course, certain relationships are forbidden. Has your fiance met and seen you within the 2-year period immediately preceding the filing of this petition? Yes. Okay, good. Describe the circumstances under which you met. If you've not personally met each other, explain how the relationship was established. If you met your fiancé or spouse through an international marriage broker, please explain those circumstances in question 19 below. Okay. Explain also in detail any reasons you may have for requesting that the requirement that you and your fiancé must have met should not apply to you. So this piece then is obviously what we're talking about in those cases that were reviewed, and what I put in here was we first met over the internet in a chat room in 2010. Then I first went to Canada in September of 2010, and Anne came down to Nashville in October of 2011, and we toured around together, and I proposed to her. She went back home. Basic information. Did you meet your fiancé through a spouse through the services of an international marriage broker? No. Okay. If you answered yes, please provide the name and any contact information you may have, including internet or street address of the international marriage broker, because we want to see if they're going to be human traffickers and where the international marriage broker is located. All right. So this is giving us a leg up on human trafficking. And just going back to 18, this statement is insufficient to show good faith intent to marry. We also have those letters of the good faith intent to marry that we covered before. Those are going to be going into a little more detail, but those are sworn under penalty of perjury and signed by both the petitioner and the fiancé. So this is just a petitioner form, the petitioner signing this, but then the fiancé is all left out. So by providing those letters, then we're giving a more complete picture of the whole case. Your fiancé will apply for visa abroad at the United States Embassy or Consulate at Toronto, Canada. Okay. And look here. Designation of a U.S. Embassy or consular post outside of the country of your fiancé's last residence does not guarantee acceptance for processing by that foreign post. Acceptance is at the discretion of the designated embassy or consulate. That's true because the embassies or consulates, they can change. They can get, have a lot of stress, shall we put it that way, be under attack. And then obviously they're not going to have that type of service available. Also, some embassies are really small and they want to give it over to an embassy that's physically bigger, where they have more room for more adjudicators, more officers, and more people to actually go through it. Other information. Okay, if you are serving overseas in the armed forces of the United States, please answer the following. Currently reside or stationed overseas, and my current mailing address is, that's not applicable. But certainly fiancés can be petitioned by U.S. citizens who are serving the military. Have you ever been convicted by a court of law, civil or criminal, or court-martialed by a military tribunal for any of the following crimes? And here's the list again: the domestic violence and the homicide, murder, really bad stuff. Or 3 or more convictions for crimes relating to control of substance and alcohol not arising from a single act. No. Okay, we already went through that with the if you have to say yes, right? Answering this question is required even if your records were sealed or otherwise cleared, or if anyone, including a judge, law enforcement officer, or attorney, told you that you no longer have a record. Using a separate sheet of paper, attach information relating to the conviction, such as crime involved, date of conviction, and sentence. So, you know, you're going to also attach the records of conviction as well, but they want you to attach your description, your take about what happened on those crimes as well. And so if you have to answer yes to any of this, you need a lawyer, people, really. Get a lawyer, and get a good lawyer. So let's see. If you have provided information about a conviction for a crime listed above and you are being battered or subject to extreme cruelty by your spouse, parent, or adult child at the time of your conviction, check all the following that apply to you. I was acting in self-defense. I violated a protection order issued for my own protection. I committed, was arrested for, was convicted of, or pled guilty to committing a crime that did not result in serious bodily injury, and there was a connection between the crime committed and my having been battered or subjected to extreme cruelty. So here are some of the exceptions that you would indicate there. All right. Now, penalties. We went through the penalties, but it's basically you may be imprisoned for not more than 5 years or $250,000 or both for entering into a marriage contract for the purpose of evading any provisions of the immigration law, and you may be fined up to $10,000 or imprisoned up to 5 years or both for knowingly and willfully falsifying or concealing a material fact or using any false document in submitting this petition. I'm legally and then the certification. I am legally able to and intend to marry my alien fiancé within 90 days of his or her arrival in the United States. I certify under penalty of perjury under the laws of the United States of America that the foregoing is true and correct. Furthermore, I authorize the release of any information from my records that USCIS needs to determine eligibility for the benefit that I am seeking. Moreover, I understand this petition, including any criminal conviction information that I am required to provide as a petitioner with this petition, as well as any related criminal background information pertaining to me that U.S. Citizenship and Immigration Services may discover independently in adjudicating the petition, will be disclosed to the beneficiary of this petition. So don't come crying about any kind of, invasion of privacy. You have just waived your privacy to the government. Okay? So if you have a problem with that, too bad. I mean, really too bad. That's their position on it. Now, yes, there are some privacies, like you're not going to, just no one can come and get a copy of this record, right? But certainly the government is going to be taking a lot of information on you and has the right to deeply dive into who you are. So, signature, blue ink here. Okay, people, blue ink, they're going to know it's an original signature, date, telephone, email address if any, put that in. And then signature person preparing form. You won't, if you've prepared it and you sign it because you've watched these videos, just do this part. If you hire an attorney or someone else to prepare to do this for you down here, then they will do this part. Okay? So that is the I-129F. That is the first part of the petition.